author of Parker-Grennan and Camelot UK Lotteries Ltd.
Mr. Counsel.
Yes, indeed. My name's Cusa. I act for Mrs. Parker-Grennan. My learned friend, Mrs. Hinks, acts for Camelot as he did below. My lord, I've had a word with Mr. Hinks, and neither of us have any matters by way of housekeeping we wish to raise. I don't know if there's anything that the bench wishes to raise.
No, safe to say that we've read thoroughly all the papers. I hope we're on top of them. We think it's a series of relatively narrow, confined issues. We would hope that we can finish within a day, but we'll let you get on with it.
Very well, my lord. I'll do just that then. My lord, by way of structure, the way in which I intend to deal with my submissions is as follows. Firstly, I'll deal with, and this won't take very long, what I'm asking the Court of Appeal to do today.
Yeah.
Secondly, I'll deal with the relevant facts.
Yeah.
Thirdly, I will deal with how the unfair terms and consumer contract regulations apply.
Yeah.
And in dealing with that, I will also address you on why it is that has to be considered before one looks at the terms and conditions, my lord. Because consumer contracts, I say, fall to be construed differently. I will then look at Camelot's contractual documentation. Fifthly, and again, this will not take very long, so please, hopefully I won't try your patience too much. What are the relevant characteristics of a consumer contract? Or of a consumer, I'm so sorry, not a consumer contract. And then lastly, I'll deal with the full grounds of appeal.
Yes.
So, my lord, dealing with that first point, what I'm asking the Court of Appeal to do on this appeal today, that is page 8 of your bundle, box 9 of the appellant notice. And you will see that we are asking you to set aside the order of Mr. Justice J, which you'll find behind tab 6.
Mm-hmm. Yep.
We did consider whether we should ask for judgment from this court, but I have to concede that Mr. Justice J, because of the way in which his judgment went, never really got on to the question of summary judgment or strikeout, and our arguments on why it is we say that the defendant can't succeed, if you're with me on this appeal. Turning then to the relevant facts, I set these out in paragraphs 5.1 to 5.7 of my skeleton argument below. That's the supplemental bundle. Pages, for your reference, C292 to 294. I don't particularly need to take you to all of those at the moment, but I will take you, because they're not disputed, I think although the consequences of what those facts lead to is hotly disputed, the fact is that I don't believe are. But I will briefly take you to paragraph 5.5. Because this sets out what we describe as the relevant contractual term. You'll see that initially the defence was, well, that was never shown to Mrs. Parker-Grennan prior to the contract being entered into, and I can tell you it's common ground, it's common ground that the contract was formed when she pressed play.
These are the words at the bottom of the screenshot that we've got in Mr. Justice J's judgment.
That's correct.
You can see them on the.
You can.
In the, yes.
And they also appear in the game procedures, which I'll take you to
Yes.
in due course. Now, what I'll say about those just very quickly is this. You'll see that it's matched any of the winning numbers, capital letters, to any of your numbers, capital letters, to win prize, capital letters.
Yeah.
And winning numbers and your numbers are plural, not singular.
Yes.
And whilst prize is singular, that's also still correct, because of course you can only win one prize per winning number. And that's important, we say, because Camelot say you can only win one prize per play, but that's not what the relevant contractual term says. That allows for there to be more than one winning number.
Yes.
Which wins. And so that's the relevant factual matrix for the purposes of this appeal, and also the application before Justice J.
And it's also common ground. I think I see it set out in your 5.6 that there was an error. I mean, the starting proposition is on the terms, on the face of the, I'm just looking at the judge's judgment, paragraph 14, where you've got the screenshot.
Yes.
On the face of it, you've got the 15, which is doubled up and animated. You've got the 1, which is doubled up and not animated.
That's correct.
You've got a statement you have won £10, not £1 million or £1,000,010. And then you've got those words at the bottom.
And that's correct, yes.
But it's common ground that there was an error. So the nub of it is, assuming that's right, there was an error, and prima facie you won 10, but on the face of this, you say you won £1,000,010. Question is, what is the effect of Camelot committing an error, technical error, upon the contractual position of your client?
Yes, I mean, the way in which we put it and put it before the judge is that what happened is something that the relevant contractual term says can happen,
Yeah.
and which the game was programmed to do.
Yeah.
And yes, it's the question of how that pans out contractually.
Yeah.
You have the point, my lord.
I mean, that's why we think it's a relatively narrow issue. But yeah, we understand your point, absolutely.
Good. Well, my lord, in that case, I'll move on to the next way in which I put it, which is how do the unfair terms in the consumer contract regulations apply? And it is common ground that the regulations apply to this contract. And I set them out in paragraph 4 of my skeleton argument below, which is a supplemental bundle again.
Yeah.
At C288292.
Yeah.
Now, they're also helpfully set out in the core bundle, in the authority bundle at tab 1. But I'm just going to take you to my skeleton argument, if I may.
Yes.
So you see which of them I rely upon in particular. So, we firstly rely upon Regulation 5.
Yes.
And we say that the terms and conditions that Camelot ought to rely upon are unfair because contrary to the requirement of good faith, and that requirement, of course, is a requirement on traders to deal fairly and openly with consumers. And contrary to that requirement of good faith, Camelot's terms and conditions cause a significant imbalance in the parties' rights and obligations under the contract to the detriment of Mrs. Parker-Grennan. And I appreciate I'm taking that pretty much verbatim from the regulation itself. Now, I'm very much giving you an overview of the regulations at the moment. I'll explain in greater detail what I mean by that when I come on to my submissions dealing with the terms and conditions themselves.
Yes.
Now, Regulation 5 places reliance on Schedule 2 to the regulations, and I set out some parts of that in paragraph 4.3 of my schedule below, 289. Perhaps I'll just ask you to read those that we set out there yourselves.
Yes.
Thank you, my lord. It's not disputed that 6.5 years before Mrs. Parker-Grennan played the game and we say won £1,010,000, that she clicked on the box that you see in the supplemental bundle at page A64. And perhaps I should take you to that.
That's when she opened the account.
When she opened the account, my lord, that's absolutely correct. And we'll see what she purported to sign up to at A64 in the supplemental bundle. It's quite clearly marked with an asterisk. By ticking the box below, you confirm that if you play the National Lottery games interactively, you have read, accept and agree to be bound by the interactive account terms and conditions, rules for interactive win games, and rules for draw-based games played interactively. In addition, when you play a particular game, you agree to be bound by the relevant game procedures and any game-specific rules which apply to that game, and confirm your acceptance of the privacy policy. And then I've read accept and agree to be bound, etc. You see that there. So she accepted she had read, in inverted commas, the 38 pages that then follow, from page 65 to 92. I'm not going to take you there because we'll look at a much clearer version in due course, but one only has to flick through the next 38 pages to see that what you're signing up to is not something that, in my respectful submission, anyone would read, and particularly not a consumer. And I'll say that's why I'm going to deal with what the characteristics of a consumer actually are as a matter of law. I mean, I think rhetorically one could say, well, would you read that before playing what is effectively a fruit machine?
Well, it might be said that she's not under any pressure of time to play this fruit machine. She's opening an account that's going to enable her to play the games that she wants to play in due course. And she has said that she read it. Now, why shouldn't she read it? There's no reason why she shouldn't.
Well, I certainly will come on and address that. I can address it now, but it's perhaps better if I take my submissions and set them out, just because otherwise I know I'll forget them. But what I would say about that is essentially this, which is that it's not the case that she just has to read them once, and then that's good for all time, because she's required to actually read them over and over and over again, because they change their terms and conditions several times a year, and you have to click on it again and again and again to say you've read all of it. And my submission, which I will develop, is that no reasonable consumer, no average consumer, I think I should put it that way, would ever read all of this, and certainly not over and over again.
I don't think you should assume that we're not unaware that most of the law relating to terms and conditions predates the digital era. And it's something we have to grapple with and we are thinking about. So we're not suggesting, if we quiz you about this, that we're suggesting this is easy.
No, my lord, I'm grateful for that indication. I wouldn't assume that you're unaware of that.
And we are all consumers.
Absolutely.
And we know what life is like.
Absolutely. And I do make the point that some of these things are facts, even though I'm going to ask you to give some general guidance, and I am, nonetheless, one has to look at it in the context of the specific contract that we're talking about. And whilst I accept my lady's point about what she's under no pressure of time, the reality is we are talking about playing, I'm going to refer to it as a fruit machine because that's what it is.
Yeah.
And if one went to a pub, there are very often rules untold on fruit machines. I don't want to give evidence from the bar, but it's inconceivable that people are going to sit there and read all of the rules.
Well, there's lots of websites, important vendors, airlines, for example, where you may be timed out very quickly, and within the allotted time, the chances of you being able to read and understand the T's and C's may be limited.
That's a very good point, and I don't know, and there is no evidence one way or the other,
No.
if there were any pressure at the time. I'm assuming, as my lady,
Yeah. But maybe when you open an account, there isn't. If you're engaging in some sort of impulse purchase at a relatively low value, which needs to be done quickly, and you're encouraged by the structure of the site to buy quickly, it may be very difficult to read the T's and C's, particularly if they're multiple clicks away. But we're not oblivious to this. What we're trying to do is get our heads around both how this operated on the facts of this case and what the broader implications might be.
Well, my lord, that's very helpful, and I'm grateful to you. Now, of course, I've made the point they have to read them over and over again whenever Camelot change their terms and conditions. But that's not all they've got to read and comprehend, because, of course, I took you to page 64 and what it is she's signing up to. And it's not just the 38 pages I've just showed you of legalese. She has to read the IWG rules, that's the rules for interactive win games. And those you find at A104 to 116. And they're up to 13 pages. They're at least a little more legible. And you also have to then read the game procedures at page 119 to 1123, 5 pages. we'll be coming back and looking at these together. But, this is the document, well, it contains the graphic rather, that was set out in Mr. Justice Jay's judgment, as you see at 119. And it also contains the relevant contractual term, which is, you'll find at page 120. It's about a third of the way down the page, and it starts instructions, and then match any of the winning numbers to any of your numbers to win prize.
Sorry, I'm just...
Yes, of course.
Page 120.
120, yes.
A120.
A120.
These are instructions of how to play and win. You say they're contractual terms, do you?
Yes, in fact, when I come to deal with the terms, I'll start off by showing you the hierarchy that Camelot set out. This is the top tier contractual document that Mr. Justice Jay sets out in his judgment. And it's
But you've got the... Then you've got the animation, seems to be part of the contractual term, the flashing.
well, I'll certainly come on to how that works. What I would say to you is, prior to her pressing play, the only contractual term that is actually set out for her to see front and centre, as it were, is the relevant contractual term, which is on the page looking at her.
Understood.
There's nothing about turning white or flashing or any of the... That you have to go to the game procedures to find. But you're right, that's there. That's the last paragraph just above, just below, it's just above prizes.
Yes.
Yes, you have that, my lord. And also, in addition to having to read all of those documents, you also have to read the rules for draw-based games played interactively and the privacy policy. Neither of which I'm going to take you to, but you still have to read them because you've clicked the box on page A64. But those aren't actually relevant to the appeal today, so we won't be taking you to them, or I certainly won't. But you've ticked the box, so you're saying you've read them. I say no one, or no, let me put it differently. The average consumer can't be expected to read all of this documentation. It's wrong, it's unfair of Camelot to assume, if it does assume, that they would do so. And the judge's answer to that, some people do, applies the wrong standard in the context of consumer contract.
He says he's reluctant to express any view, and then he says some people do.
Yes, that's correct. 44 and 45, I think, are the relevant paragraphs.
Yeah.
And I've made the point that it's not even enough for a really motivated consumer to read all of that once, because Mr. Smith, who is an employee of Camelot, produced a witness statement below. This is your supplemental bundle at pages... It starts at A26, I think. Let me just get you the reference. From A22 to A35. But I'm going to ask you to turn up paragraph 19 of his witness statement, which is A26 to A27. Perhaps I can just invite you to read paragraph 19 for yourself. So, my lady, that deals, hopefully deals with the point about, well, one could perhaps take an hour or even 2 hours at a time to go through 38 pages plus the other documents once off to play the game. But of course, that's not the position at all.
But the judge took the view that the original terms were not relevant because they were constantly updated, and therefore you looked at the terms as of the time you played the game.
And those are the terms we will be going to.
Yes.
But of course, in terms of, I don't want to use the term, but when one looks at the account and having signed up to the account, what one signed up to is that. And the reason I say that is relevant is because if you were the highly motivated consumer who actually did click on the link and started to look at that, you could well understand why you might never click on the link again, if that's what you're going to be faced with. And so I do say it's relevant, and perhaps if one way Camelot could have dealt with that is to say, we have made everything much clearer now. please, even if you didn't read it before, do so now. Well, we don't know what Camelot did. And I say, reasonably, and this is the correct test that the judge should have applied, reasonably well-informed and reasonably observant and circumspect consumer is going to read all of those documents, and it's wholly unfair of Camelot to attempt to say otherwise. Now, I'll take you to authority in a moment in respect of those submissions, but before I do, let me show you the account terms updated, which are in force when Mrs. Parker-Grennan played the game. This is, again, the supplemental bundle, A93 to A103. And again, these are more legible, I readily accept that.
Even the terms in force at the time of the game, are they?
That's correct, Mr. Levy. And whilst they're more legible, first and foremost, it assumes that anyone's going to click on them in the first place. And secondly, the average consumer, so reasonably observant, reasonably circumspect, simply isn't going to take the time to do this several times a year. And in truth, Camelot cannot seriously intend consumers, all of the consumers who play their games, to read all of these terms and conditions before playing their games. For two reasons. Firstly, because human nature tells us they wouldn't have any more customers if they did, because no one else is doing that either. And secondly, there are ways in which they could enforce compliance upon consumers, or certainly better enforce compliance upon consumers. And I'll come to that more fully when I come to invite you to give guidance. But I do say that simply saying, tick here to say you have read all of these documents without any requirement that you actually click on the link first of all is insufficient in the context of a consumer contract.
I take the forensic point that clicking on the box without requiring first to click on the link makes no sense because you can't police it. But are you saying that if you did have a requirement to click on the link, that would be enough?
No, what I was saying to you in due course, what I'll say now, is that what you would require is to click on the link and then scroll, at the very least scroll through, even if you do it at the speed of light, scroll through until you get to the bottom, and at that point, the I accept or I agree, whatever the box might say, becomes clickable. And contrary to what Mr. Hinks says to you in his skeleton argument, that actually won't create a difference between online transactions and real-world transactions. What it will do is harmonise the position, because one goes into a store, physically goes into a store, and purchases something with a written contract with terms and conditions on it. One has to sign underneath the terms and conditions. So one has an opportunity to read them, even if one doesn't avail themselves of it. And so having a situation where you are forced to scroll through the terms and conditions, whether you avail yourself of the opportunity to read them in detail or not, at least means you were given the opportunity to read them. And you can't complain then about their contents. Whereas I say it's quite different to have a situation where you haven't even got to click on the link and you haven't got to scroll through the terms and conditions, my lord.
But you're still given the opportunity on the one click, aren't you? I mean, you know that if you do click, you can then read them.
My lord, whilst I accept that, one has to, when one is a trader and dealing fairly with a consumer, look to human nature as part of that. And so you take a horse to water, as it were, but you can't make it drink. You can take the consumer to where they are. You can force them, at the very least, to scroll through those terms and conditions.
That's not going to get them any better off, because what will happen is they'll just go through and they won't read them then.
Well, they may or may not. And even then, at least they've had the opportunity to, or the opportunity has been forced upon them, if I can put it that way.
They've had more of an opportunity.
Your point is it's better than the present, even if it's
better
not
than the
perfect.
present. Of course, even then, the terms and conditions might fall foul of the unfair terms and consumer contract. Yeah, you have my point.
I mean, under the, I'm just, I haven't got the regulation in front of me. One of the terms which go to the reasonableness as opposed to incorporation is also the ability to read the terms and conditions.
Intelligibility, yes.
Yeah. So it applies both in terms of incorporation and intelligibility or reasonableness.
It does, my lord, yes. It does. My lord, can I just, I don't think it's relevant at this point, take you to the decision?
Can I just, so
Yes,
in
please do.
relation to the structure that you referred to, that's increasingly the way in which websites force upon you a choice to accept or reject all cookies. And I suspect you have to go through more steps now to get to the reject all, which is what I invariably go for. But you have to go down the list, identify the cookies, and they become ever more complicated because you can never work out whether you have to push the little button to the right or the left, because often they refrain from telling you that, so that you don't, it's not that easy to make the correct choice. But actually going through a series of steps forces you to address the question of accept or reject all cookies.
It does, my lord, it does. And these, of course, the point I made to your lordship, these are matters that really the trader acting fairly has to take into account that the consumer isn't necessarily motivated by their own, well, they're motivated by their perceived best interests at the time, rather than by their best interests over time, if that makes sense as a submission.
There's a difficult conflict that traders face, which is, on the one hand, they want you to purchase quickly and repetitively, yet at the same time, they need to get you to read their T's and C's. It's a very difficult balance they have to strike. On the other hand, the other side of the equation, I mean, you can sympathise with traders on that basis. On the other side of the equation, consumers don't want to be troubled with T's and C's because they're a burden. They just want to make a quick purchase, 5 quid, 10 quid, and move on, add something else into the basket. In this in this digital era, how is the balance to be struck? Because traders have an interest in making sure that there are T's and C's and both sides are protected reasonably and fairly. How do you get that message across? Unless it's through presumed reading and clicking.
And I think it does have to be that, because as you'll see when I invite you to give guidance, I'm not suggesting for a second that click wrap tick box exercise is always wrong in the context of a consumer contract. I don't say that, because you're right, it benefits the consumers as well to be able to circumvent that if that's what they perceive to be what they want to do. But they have to have the choice forced upon them in the first place to have scrolled through it. And as my lord rightly observes, traders already do that in respect of other online items such as cookies. And some traders, as the judge adverted to in his judgment, also do what I'm proposing, which is that you don't get a chance to accept unless you have at least scrolled through. I mean, Mr. Donaldson, QC, I'm going to take you to his judgment in Spreadex in a moment. He made the point that the time expended on dealing with the whole signing up process would, in any event, give the trader a fair idea that no one had actually bothered to read the terms and conditions in the first place. But you're right, my lord, you have to have some sort of happy medium between it. And so I do say that forcing the consumer to the very least have clicked on the box and then scrolled their way through the terms and conditions, even if you can't force them to read it. You can't say you've got to take 20 minutes, because if they'll just walk away, make a cup of tea, watch a television programme, come back in 20 minutes. So that there is
give up and you don't get the sale if you're the trader.
And from the trader's point of view, that's disastrous. Yes, absolutely. So it is about a happy medium, and I say that can be struck by requiring them to, at the very least, scroll through, which is equivalent, I say, to what happens in the real world when one goes into a shop and one's presented with a written contract with terms and conditions on the back, which then have a signature box at the bottom. You've got to get past the signature box, scroll past it however you want to put it. You've got to get past the, not the signature box. To get to the signature box, you've got to get past the terms and conditions before you can sign up. And that's effectively all I'm suggesting, but in a digital context.
In your view, would that always be fair and reasonable? let's assume that you've got 40 pages of small text which you have to scroll through before you get to the click box, and the website is structured so that it's in inevitability that you're never going to read the 40 pages. You're just going to go, end of document, click. And that's the way it's structured. It's a small value purchase. You, the consumer, want to get it with minimum fuss. The chances that you're going to look at clause 18, subparagraph B2 is virtually zero, yet you go to the bottom. In law, would that always be satisfactory in your view?
No, because as I say, even if you get past that initial concern that what they've done is not enough by simply having the front page that you can just press I agree, you then would still get into the other aspects of the unfair terms.
So it's incorporation only, not fairness.
Exactly. My lord, I said I'd taken spread X. Perhaps I can do so.
I'm sorry to interrupt.
No, my lord, please do.
You, when you were taking us to the terms and conditions, you said, I hope I've written this down correctly, no average consumer would read these terms and conditions.
Yes.
Well, so whether you're forcing them to scroll through or not, they wouldn't read them.
Yes, but well, I see why you picked me up on that point, my lord. The reality is, I think that no average consumer is going to read those. I suppose I have to concede what Mr. Justice Jay said in his judgment, which, well, some do. At least in this way, the average consumer who doesn't read them cannot say, well, I didn't have the opportunity to read them. Whereas
Can't say he didn't have the opportunity to read them with the first click either. That's the point my lord made about 5 minutes ago.
Yeah.
All he can say is he's had a better opportunity to read them.
Well, a much better opportunity to read them because, of course, he or she, the consumer, has been forced to scroll through them.
Yeah.
So, yeah, subject to my adding the word much to better, I accept my lady's proposition, yes. I don't know if that addresses...
Sorry, I interrupted you. You're about to take us to an authority.
No, my lord, I'm grateful for the...
There is no perfect solution to this. That's one of the problems, isn't it? None of these laws actually cater for the delay.
That's correct. Yes, I'm going to take spread X, which is tab 7 of the All Authorities bundle. Passages I rely upon are paragraphs 6 to 8 inclusive, 10 to 12 inclusive, 16 to 19 inclusive, and in particular 19, and then finally paragraph 21. Perhaps I should invite you to read those to yourself. I'll be happy to read
Can you
them.
give us the list again, please?
Yes, of course, my lady. It's 6 to 8,
Yes,
10 to 12,
yes.
6 to 19, 16 to 19, I apologise,
Particularly 19.
particularly 19, and 21.
Thank you.
So, my lord, you see the last sentence of paragraph 19 and what Mr. Donaldson says about having to assess fairness in the light of all the situations in which a term is potentially applicable. And that was cited with approval by the judge in his judgment. He expressly set it out. And you also see what he says about click-wrap documents in paragraph 21 and the footnote to paragraph 21.
What's meant by all in paragraph 19? We all know, and I don't think it will be a dispute, that there is a category of person who are consumers who are digitally incompetent. Elderly, some elderly people, for example, some not so elderly people. But there is I don't know what the percentage is, one sees figures, but it's not insignificant. They're people who would fall within the all.
They are, my lord, and so and I accept that it's about trying to find a perfect solution in an imperfect world, and we're not going to be able to do that, but we can certainly do better than we presently have, because you do have to take into account as a trader that some of the people you will be dealing with will fall into that category of digitally incompetent, and it's about doing as much as is possible, reasonably possible, to deal with that potential situation. Now, so that's regulation 5 of the regulations. That brings us then to regulation 6, which I set out at paragraph 4.4 of my skeleton argument. It's a supplemental bundle again. It's at C290. And so you see the
Sorry, did you say C2? Yes.
C,
C1, is it?
no, C290, my lord, paragraph 4.4.
C2. So it's supplementary bundle.
Yes.
Look at my C2 says defendant's skeleton argument.
Actually, in C1, it's the
290.
page numbers down at the bottom right.
290.
290.
That's correct, yes, I apologise.
No, not at all. Thanks. Yep. So Reg 6.
Yeah, indeed, my lord. My lord, I'll just turn my back on you for one moment, if I may, to speak to my instructing sir. Thank you, Lord. So, in assessing unfairness, you have to look at the nature of the services, in this case services, provided, goods or services, circumstances attending the conclusion of the contract, and all the other terms of the contract. So that includes the relevant contractual term. And that will become highly relevant, I say, when one reads that alongside Regulation 7.2. But before I get to Regulation 7.2, and this is a point I could have dealt with when I come to the grounds of appeal, but I'll deal with it now because it sort of fits in properly here, and it just means the grounds of appeal I can take more quickly, or that aspect of the grounds of appeal, which is what Mr. Justice J described as a jury point, namely the inadequacy of Camelot.
1900 tests.
Exactly, my lord, exactly. And I do say that that's inadequate, and I'll take you through the numbers, because that goes to the issue of allocation of risk under a consumer contract, which is, to say, my first ground of appeal. And what I say is that Camelot want to allocate all of the risk of this undetected coding error away from themselves in circumstances where they could have detected the error, and into the lap of Mrs. Parker-Grennan, who had no way of detecting the error, even if she wanted to, or tried to. we say that's simply unfair in the context of a consumer contract, any consumer contract. It's particularly unfair in the particular circumstances of this case, because there's not even been an attempt to comprehensively test the game before making it available to be played by consumers.
Well, what's so fair about allowing a consumer to get advantage of a computing error?
Well, she hasn't taken advantage of a computing error. What she has done is gone to a game that says match any of your numbers to any winning numbers, or any winning numbers to your numbers, I forget which way around it goes, to win prize. So that's what it says it can do. It's been programmed by Camelot to do just that. That's not taking advantage, that's winning, my lady, with respect.
I think,
But it only does it because of an error.
yeah, I think that's what my latest point is, that the Camelot didn't intend for you to win twice. They thought they were programming their computer to give the winners just one prize, one set of winning numbers. That's what they thought they were doing.
And that's exactly right, my lord. And that's the point. Excuse me, my lord. When one looks at a contract, one doesn't look at what is subjectively intended by Camelot. One looks at what is the objective result under what it said could happen.
Well, that's the $64,000 question, isn't it?
My lord, I'll leave that to wiser heads that sit at the front of the court rather than to me, because yes, it is. The reality, however, is that what Camelot intended to happen is neither here nor there for the purposes of this submission. What matters is, could Camelot have detected it? And we know that Camelot could. I'll take you to the numbers in a second by the reference to Mr. Smith's witness statement. And had they have tested it more comprehensively, then they wouldn't have released it to the public in that form.
Are you saying that the statistical testing was inadequate to detect the error?
Yes, I am.
And where's the evidence to support that?
Certainly, let me take you to that. So it's
Can I ask just another question?
Yes, of course.
How is it? I think you put your finger on the nail when you said it's a question about allocation of risk. Who should bear the risk of an error?
Yes.
Does it matter who is responsible for the error? We assume there is an error. Let's assume, for the sake of argument, that had Camelot tested it 500,000 times, they would have avoided it. But it's common ground there was an error. You say the question is who should bear the risk of the error?
I do.
And in that, are you saying that whether they adequately tested is relevant to that, or is it really a matter of elementary fairness? The court just looks and says there's an imbalance because you've got a large organisation and consumers who pay quickly. I mean, what does it actually go to?
It goes towards the question of fairness, i.e. open, and I forget the meaning, but open, clear and open dealing with the consumer by the trader. I don't think, my submission is, it's simply not fair for Camelot to say, we've tested this for 40 minutes, and I say, my lady, I will take you to the evidence in a second. We've tested this for effectively what is 40 minutes of actual gameplay. Let's let that go live. You couldn't imagine Ford or General Motors testing a car for 40 minutes and then saying, well, we'll just take our chances.
I guess it depends upon the technology and whether 1900 is, even if you could have done it 1,000,000 times, question is whether 1900 is statistically significant to enable it to go live. So it's comparisons are very difficult, I think, here.
Shall I take you to the numbers and then perhaps you'll have a clearer idea?
But you're saying that the avoidability of the error as a matter of fact is relevant to fairness.
I do say it's relevant to fairness, absolutely.
And a second level question is, assume there's an error, and irrespective of whose fault it is, how you allocate risk for that error is also a question of fairness. I mean, let's assume you're wrong on this. Assume for the sake of your, and that it's common ground there is an error, and they have, on their terms, they seek to obviate the risk of that error to themselves and shift it to you.
Correct.
On your analysis, do you need to know as to whether or not it's a reasonably incurred error or a not reasonably incurred error? Was it just an error? It wasn't your error, it was their error. That's common ground.
Well, it could never have been our error, of course.
No. And you could never have detected it.
No.
I suppose it was an error that they couldn't have detected. Sometimes you get glitches in computer programs that nobody can spot.
I mean, because I'm just wondering if you have a second line of the argument that whether it's a reason, it was their error, you could never have detected it. They're the system creator.
Therefore, the risk should be on them.
Therefore, the risk should be on them because of the inequality of bargaining power. I mean, that's another way of looking at it.
That is, and yes, I do press that, my lord. I hadn't actually considered the point about an error that couldn't be detected. I'm afraid I don't know enough about computers to know if there is such a thing as an undetectable error. But I'm willing to say
Very, very, very difficult to detect, for example. Almost everything can be detected with sufficient time and skill and so on.
Yes, okay. So had Camelot tested
beyond reasonable testing, let us say.
And that's what I'm trying to get at.
Yeah.
And what would be the? I think in those circumstances, well, just think about that. Well, if they tested it a reasonable amount of time, whatever, a reasonable amount of times of the play, that they discharge what I say is the duty on them to test it properly, then I think I would be in a much more difficult position. I have to accept that. It would still be their
client
error.
doesn't know at the time that she's playing the game. She has no idea whether they tested it once, 15 times, or 150 or 3 million.
Well, that's the very point, that a consumer is entitled to assume that a trader will protect their own interests, if one wants to put it that way, or certainly protect everyone's interests by having tested the product in question a sufficient number of times so that they have reasonably discharged that duty.
I mean, this is a bigger issue than perhaps one imagines. Let's assume in 5 years' time, when AI is governing a very, very much larger number of processes than it does now, how is a court to work out whether this is a reasonable error or an unreasonable error as a constituent of the analysis of whether a term is reasonable under the unfair contract terms regulations? This may be a very low-level error in the overall scheme of AI-generated iterative learning processes, which we're going to get and are getting increasingly throughout business. To impose upon the court to work out whether or not the error was reasonable or unreasonable might be a huge burden in the context of applying the unfair contract terms regs.
Well, my lord, I'm loath to speculate about what might happen once AI does whatever it is AI is going to do. What I would say is that in this case, once we look at the numbers, I don't think it's I don't think I'm imposing an enormous burden upon this court.
No, I'm not suggesting. I'm one of the things which lurks behind this case are the wider implications, and the invitation to express guidelines is something we're going to have to really seriously think about, whether it is something which we can do or whether the implications of anything we say are potentially very far-reaching unless we're very careful.
Well, my lord, I do accept that. What I would say, however, is that, of course, one of the beauties of our system of law is that matters can be revisited as the factual matrices alter over time.
Yeah.
Now, you're right. 50 years ago, if I was inviting the Court of Appeal to give guidance on something, it would be with a view to that guidance persisting for decades. And the world has become a much faster place, but I'm not sure that that's the reason to, I'm not going to say shirk, but to decline to give guidance for what is happening now, even if in 5 years' time, if that were the correct time frame, matters had moved on sufficiently, such that more guidance would need to be given or the guidance clarified.
But the nub of your point is it's the reasonableness of the error as opposed to who is responsible for the error.
Yes, my lord. Well,
That's your second line, is who is responsible is pivotal. Your first line is this was an unreasonable error.
yes. Now,
You're going to take us to the evidence?
yes, my lord. I was just good to see. Yes. So we go. It's okay. Supplemental bundle at page A32.
This is Mr. Smith's witness statement.
This is Mr. Smith.
31, paragraph 37,
Coding error does indeed,
Yeah,
my lady.
well,
So perhaps it might
we really need to know what the error was, don't we, before we start looking at the explanation.
very well, my lady.
He says it was an accidental human coding error.
He does.
For a small number of plays, this resulted in an erroneous -1 value being inserted in the code.
Correct, my lady.
And it also depended on what sort of system you were using.
It did, my lady. Yes, that's A31 then, my lady. And I particularly relied on 39 to 41.
Yeah.
Thank you, my lord. And so the numbers to take from that are, well, extensively, in inverted commas, about 1900 plays of the game. Excuse me. The game was live for 36 hours. And during that time, it was played 101,698 times.
That's after the testing.
That's after the testing is.
Yeah, the issue was live for 36 hours.
Yes.
So the game went out with this glitch in it for 36 hours.
That's correct.
And 99.76 people who played it had no problem.
Yes, my lady. But if we take it in terms of the testing regime, if we take 101,698 and divide that by 36, one gets 2,825 plays of the game per hour. And so by testing it 1900 times, the extensive testing that Camelot boast about,
It's not how statistics work.
well,
Sorry.
We
This
need
is
to
a
know.
completely false exercise.
well, my lady, I'm afraid I say it's not what, and it works on Mr. Smith's.
No.
no.
The whole premise of the exercise that you're doing with this dividing it up between the hours, it just doesn't work statistically. I'm sorry.
Well,
One's got to know in absolute terms what 1900, what the risk of an error being determined by 1900 plays would be.
well,
For statistically to know whether or not that's sufficient, and then there could be all sorts of industry practice to determine what's statistically significant for error detection.
well, I'm afraid no evidence is led by Mr. Smith
No.
in that respect.
No,
I can
It's
only
you
go.
that's making the point.
I'm so sorry.
It's you that's making the point.
Well, I am by reference to the numbers that Mr. Smith sets out. Well, my lady,
I mean, you're entitled to say there was an error, it was their fault, it was not your fault.
yes.
The separate question is whether or not that was reasonable on their part to only test it through 1900 play scenarios. We do have some difficulty in working out the statistical significance of this number, though we accept that it was their error, it wasn't your fault, and they are responsible for the error, whether reasonable or not. I mean, we understand the evidence, we see it. We have, as I say, we just have some difficulty in working out statistically whether 1900 is significant or not.
I can only go on the
No,
evidence.
no, we understand that.
Yeah.
Yeah. Yeah.
I mean, and I suppose that also deals with my next point, which is that where Mr. Smith says, well, no testing regime is 100% guaranteed to detect errors, and that really then comes back to the point that was made about the undetectable glitch. That
But
actually
your point is, so be it, it's still their error.
still their error. That's it.
That's certainly a better point than the statistical one, because we haven't got the information to do it in a statistically meaningful way.
No. Well, my lady, I can only take to the evidence I can take you to.
No, we understand.
Now, on the question of fairness, there's this, which is that Camelot attempt to allocate all the risk, as we know, to Mrs. Parker-Grennan, and it wasn't her fault, quite simply. One of the things that Camelot rely upon is the integrity of their pricing structure and the importance of maintaining that. But in my respectful submission, that's something of a red herring. And the reason for that is because if Camelot made the mistake themselves, and I very much doubt they did, I don't suppose they do their own coding, but if they did, well, why should they be forgiven their own mistake? But if it was a third-party software provider, as seems inherently likely, well, then they can preserve the integrity of their pricing structure by suing the third-party software coding providers.
So hypothetically, if a computer error happens to award somebody £1 million, which they shouldn't have got, the third-party software coding providers have to stump up that £1 million.
Well, that's why in business we have insurance.
Yeah, basically treating them as if they're insurers.
When it's up to them, they take the risk. They either pay up or they insure against the risk.
Exactly so, but that's a commercial decision. My point is a slightly simpler one, which is that to the extent that you're troubled by the integrity of Camelot's pricing structures, there are ways in which Camelot can deal with that. And finally, on regulation 6, before we move on, unfairness is to be assessed taking into account the nature of the goods or services under the contract. And here we're talking about a service worth £1 million. And that has the potential to be, I would say, in most, if not all cases, far more than would ordinarily be the norm under a consumer contract. And so it's the value of what can, not what is, in the particular case, as Mr. Donaldson QC made clear in paragraph 19 of Spreadex. It's what can be at stake that one has to look at in assessing whether a particular term excluding liability or limiting liability is relevant to the question of fairness in the context of a consumer contract.
Well, Spreadex is a very different kettle of fish because you're dealing with trading which exposes the person who's playing the game, if you like, to potentially huge losses. The person who plays the lottery stands to lose no more than the stake that they pay for their lottery ticket.
If it's a contract for difference, my understanding is that yes, that's correct. It depends on exactly what the trading platform would do. I think it was a contract for difference in the Spreadex case. So in that respect, yes, my lady, I agree. Your liability is clearly fixed at £5 in the case of Mrs. Parker-Grennan. If one looks at liability as being the extent of what she's wagered and not the extent of what she's won.
But I was just querying how you measure the value of the goods or services. Are you saying you measure, for the purposes of a game of this nature, that you measure the value of the goods or services by the highest prize that somebody could potentially win?
Well, certainly in the circumstances of Mrs. Parker-Grennan, yes, because that's what she in fact won. But of course, that's not quite. Mr. Donaldson goes further in Spreadex and says you have to look at all the situations in which it's potentially liable. So,
well, leave aside Mr. Donaldson because I don't think you've got a direct analogy.
very well.
If we're actually thinking about a gaming contract, which is what we've got here, a lottery contract, how do you say you measure the value of the services that are being provided by the lottery operator to the consumer, because we can't just look at it purely from the point of view of your client. You've got to ask yourself, from the point of view of these regulations, what factors do you take into account in determining fairness and unfairness?
Is it linked, just following up, is it linked to, do you make the assessment at the point of time of making the contract or after the event? Because at the point of time of making the contract, you have a prospect of winning a sum of money, which decreases as the sum of money goes up. So the chances of winning $1 million are very small, but you have a chance at that point. After the event, in the case of your client, she has $1 million. But is that the right point in time to make the assessment?
No, and the regulations say that. Regulation 6 says at the point that the contract's concluded, which, as I've already made clear, is common ground. That's when Mrs. Parker-Grennan
Presses play.
No, I mean, if she presses play and for whatever reason the game breaks down, what she's lost is a chance to win $1 million.
Which is apparently 1 in 4 million.
They're not great odds, certainly. 4.86, I think it might have been. But yes.
Okay.
So, Regulation 7 then, back in the supplemental bundle.
This is the contra preferentum point.
It is. Well, yes. This is page 291 of the supplemental bundle. I do say Regulation 7.2 has to be read in conjunction with 6.1, so it goes slightly wider than the common law contra preferentum rule. So, my lord, to start with 7.1, a seller or supplier should ensure that any written term of a contract is expressed in plain, intelligible language. And what I say is it can't be intelligible if it can't be read in the first place, such as the original terms and conditions that I took you to for the opening of the contract, or if it won't be read at all. And that comes back to the reasonableness of what it is that one can expect the average consumer to do, if not coerced into doing something else.
I understand the point about it not being intelligible if you can't read it.
Yes.
Either because it's in such small print that your eyesight will give up before you get a chance, or because it makes no sense when you do because it's written in authentic frontier gibberish. But if somebody won't read it, that has no bearing on its intelligibility at all. Surely. Two things are different. Intelligibility presumes you read it, and it's to do with its comprehensibility or understanding, if you do.
I suppose this is Schedule 2(1)(I), irrevocably binding the consumer to terms which he had no real opportunity of becoming acquainted with before the conclusion of the contract.
Correct.
I think that's
correct.
the legal basis of your point, isn't it?
Yes. So, well, one then goes to Regulation 7.2. Just out about the meaning of a written term, the interpretation that's most favourable to the consumer shall prevail. And then Regulation 12, which I don't need to trouble you with. And that operates in two ways, I say. Because an individual term might contradict itself. So it could say something along the lines as the example I used below. If you win, you'll be entitled to £200 and we will pay you £100. And that clearly just contradicts itself. That's the easy application of 7.2 because there you say, well, you get £200. But it can also be that an individual term of a contract can contradict another individual term within either that contract or another contract on which it's dependent. And that's because Regulation 6 says so. So the part of Regulation 6 I rely upon in that respect, back at 288, no it's not, it's back at 290. The unfairness of contractual terms shall be assessed, taking into account the other terms of the contract or of another contract on which it's dependent.
Mhm.
So assessing unfairness, you take into account all the other terms of the contract, and if there is doubt between the terms, this is why I could say it goes slightly further than the common law contrapreferential rule. If there is doubt as between the terms, then it's the term which is most favourable to the consumer to which you give effect, which must prevail, is the wording. Now, the learned judge dismisses that argument in paragraphs 86 and 112 of his judgment, which for your note is pages 93 and 97 of the core bundle. Perhaps I could invite you to read 86, paragraph 86, and paragraph 112.
This was in relation to 13.3 of the...
The hierarchy clause, which I'm going to take you to in the next section
Yes.
of my submissions, yes. But the key point is he rejects the submission that I make, that regulations 6.1 and 7.2 have to be read in conjunction with one another because they interact. And he does so without considering that argument. At no point does he consider how 6.1 and 7.2 interact. And I say he falls into error in approaching it in that way.
Which we've got the hierarchy set out in the judgment, the 13.3 hierarchy. Which other provisions do you say it conflicts with? Where is the ambiguity to which 7.2 applies?
Well,
Doubt.
Certainly. The very obvious one is in the game procedures themselves. I'll just have to turn you up the reference there. Just give me 1 second. So if one no, yes, of course. The document I'm going to bring you on to when I come to look at Camelot's contractual documentation is at tab A11 of the core bundle. It's page A149, which sets out the relevant contractual clauses in a way that's actually intelligible. And if you go to page A155, it actually starts over at 154, which is game procedures, and sets out some of the game procedures. And it's at 155 that I take you to. And about halfway down the page, you see the word instructions, and then match any of the winning numbers to any of your numbers to win prize. Do you have that, my lord?
So on 155.
155, my lord, yes.
Hey,
About just over halfway down the page. So that's the relevant contractual term.
Sorry, I'm just making sure I've got the right page.
Yes, of course.
Oh yes, I've got it.
Thank you.
Yes. And these are the words on the bottom of the screenshot.
They are. That's what I described.
Which is what I'm trying to get at. So you're saying effectively the words on the tin as it was put. What was seen on the screenshot are, in your view, the terms and conditions which bind.
Yes, my lord.
If there's anything inconsistent, such as 13.3, the hierarchy, you say that the inconsistency has to be resolved in your favour because of 7.2.
Well, I certainly do say that, but of course there is no inconsistency with 13.3, the hierarchy,
Yeah.
because the principal game, or the principal contractual tier, top tier contractual document is the game procedures.
Yes.
So it is this document that we're looking at here. And you see that there, match any winning numbers to any of your numbers to win prize. And then further down on the same game procedures, so within the same document, if you match a number from the winning numbers section to a number in your numbers section, the two matching numbers will turn white and flash in a green circle, indicating you've won the prize for the match to your numbers. And to the extent that that contradicts the match any of the winning numbers to any of your numbers to win prize.
Well, that begs the question, does it contradict it?
Well, it's said by Camelot that it does, because what they say is it didn't. Your number one didn't turn white and flash, but nowhere does it say that on the game screen. And when one looks at this document, to the extent you say, well, those two matters are inconsistent with one another, well then, when one reads 7.2 and 6.1 as a piece, one sees that one has to give effect to what I call the relevant contractual term.
So you say there's an inconsistency between the bit saying match any of your numbers and the bit that says you put out a flashing symbol.
It's more the point that Camelot say that, in fact. They say, therefore you cannot have one because yours didn't turn white and flash.
Well, that doesn't mean there's an inconsistency. What they're saying is it's a requirement that they match and that there's a flash.
I mean, boiled down to bare essentials, we have to decide whether this is just a simple question of construction, and if there is a doubt. If there's a doubt, 7.2 means that we construe it in your favour, but you have to start with the normal principle of construction first, which is why I'm slightly puzzled that the clash is said to be with 13.3 as opposed to, as I think we're now focusing upon, the actual words which were on the screenshot. So the inconsistency you say is on the words on the screenshot, or is it with 13.3? If so, how does the hierarchy?
No, it's not with 13.3.
Right.
It is the screenshot, because the
Okay.
screenshot tells, it's the only contractual term that's presented to Mrs.
When she
Parker-Grennan
presses.
before she presses.
Yeah.
So that's what binds her at the point she presses.
Right.
Nothing else is there. There's nothing inconsistent.
Okay. And there's nothing in the terms and conditions which lurk behind in those many documents which allocate risk for an error. Nothing explicitly, is there?
I don't believe there is. I'll be corrected if I'm wrong about that, but I don't believe there is.
I mean, if it had allocated error away from Camelot to you, it might be said that that's unfair. But the absolute essence of this is how one construes the words, if you like, in the judge's screenshot in small letters at the bottom.
In fact, if one looks at page 152, one sees limitation of liability. And what it says at 11.4, Camelot will not be liable to any person for any mistakes caused by all or part of the computer systems or
I see, yes. Right.
Camelot. So the records cannot be relevant, and computer systems. I need to look through that's a defined term.
Well, mistakes is fairly broad. I mean, this would be viewed as a mistake.
Yes, I think. So the question then is whether that is reasonably incorporated into the contract, whether it's reasonable to incorporate it into the consumer contract.
Yeah. Okay. All right. Well, we'll find out in due course the extent to which that's relied upon, as opposed to just as the issue of construction.
Lord, yes. I'll just finish up on the unfair terms of consumer contract regulations with Regulation 8, which is in paragraph 4.7 of my skeleton argument below, as supplemental bundle C292. I don't trouble you with for very long. An unfair term in the contract concluded with the consumer by a seller or supplier should not be binding on the consumer, and the contract should continue to bind the parties if it's capable of continuing in existence, which this would be, we say. That then brings us back to the document we're just looking at together, because I move now to the relevant part of Camelot's terms and conditions.
Yes.
We accept. Mrs. Parker-Grennan signed up to 6.5 years before playing the game. And I've taken you to what it is she signed up to. I won't take you back there.
Yes.
Now, I think it's helpful to start with clause 13.3, because that's the hierarchy of the provision. And that's at page A154 in the core bundle. So I can invite you to read that yourself.
I'm so sorry, I was just looking at something else. Just give me that reference again. Sorry.
It's the interactive, the IWG rules, clause 13.3, and it's at page A154.
This is the hierarchy.
It's the hierarchy, exactly.
Absolutely, I've got that.
And so in terms of, on Camelot's case, what is the top tier for contractual provision? Well, there were no applicable game-specific rules in respect of this game. And so the first document we get to as being of importance is the game procedures. And the judge sets that out in paragraph 9 of his judgment at page A73, but I don't need to take you to that. And after that, it's the IWG rules, and then the account terms, and then relevant here is the game detail screen, which is the other place. So we see the relevant contractual term in the game procedures, but we also see it in the game details screen as reproduced by the learned judge in his judgment.
Yes.
And I say that when you look at that in the context of regulations 6.1 and 7.2 and how they interact together, what one has is that to the extent that there's ambiguity between any other terms, and by ambiguity I do include an attempt to get away from what the relevant contractual terms said could happen, which did in fact happen because it's been programmed to happen, albeit in error, that is an ambiguity because
How can it be an ambiguity? That's mangling the language with respect. Ambiguity means something has more than one meaning. Doesn't mean it's inconsistent.
well, my lady, the ambiguity, I suppose, certainly if one looks at it from the perspective of the consumer, would be that they've been told that they have to do a certain thing, they've achieved that certain thing, and then they're being told, but you're not going to be paid out. Not sure I can put it any higher than that.
Well, I think we'll have to agree to differ as to whether that's an ambiguity. It may be a disappointment, it may be a leading them up the garden path, it may be all sorts of things, but it doesn't mean that it has any different meaning.
Certainly I accept that so far as the relevant contractual term is concerned. But one comes back to the principle of treating consumers with fair.
Yeah, I see your overall point in terms of fairness. At the moment, I'm struggling to fit it in with this business of clause 13.3 and 6.2 and 7. Overall, you say the consumer was led to believe that X would happen and it didn't. And because she was led to believe that X would happen and it didn't, that's because of the small print, then you've got to look at the small print very carefully to see whether that was fair.
Yes, I mean, what I say is that prior to the contract being formed, when she pressed play, the relevant contractual term is what the contract was based upon.
Yeah, you say that the original what she saw was what she expected to happen, and then it didn't, and there's no justification for that.
Yeah, I say that's a breach of contract. Yes, you have my point, my lady.
Yeah.
Now, on the question of incorporation, can I invite you to turn up the decision of Mrs. Justice Foster in the Betford case? That's tab 11 of your authority bundle.
It's always good to cite cases where you won, isn't it, Mr. Cowan?
It's not something that happens very often to me.
Tush.
The passages I rely upon, my lord, are paragraphs 15 to 18 inclusive, and 166 to 169 inclusive. And perhaps I can invite you to read
Sorry,
that.
which were the first ones? I got 166 to 169.
Certainly 15 to 18.
Thank you.
171 and 172 are quite interesting.
Yes. You're quite right, my lord, yes. And I think this really just reinforces the point I was discussing with your ladyship a moment ago, which is that we know that what was presented to Mrs. Parker-Grennan prior to pressing play is the contractual clause I rely upon, which sets out the contractual clause I rely upon. And of course, that's taken verbatim from the top tier contractual document, the game procedures. If we go back into the core bundle and the relevant contractual clauses set out at tab A11, page A149 and onwards. I'll also take you to the IWG rules, starting at page A151. And at 151, if one starts at rule 3.1 and reads down to rule 13, which finishes with rule 13.3 on A154, you'll see the clauses that we say are relevant for the purpose of disposing of this.
Sorry, which bundle are we now in?
We're in the core bundle now, my lady.
Right, thanks.
And we're at page A151.
Thank you. Yes.
And I invite you to read those clauses to yourself.
Presumably the numbers that are interpolated, 36, 37, 38 with footnotes, which we don't have replicated here.
I wondered that myself. I didn't actually. That's a more cogent answer than I'd managed to come up with. I assumed it was just a typo. But,
Well, I presume that they're references to definitions somewhere.
they may be, my lady. I'll turn my back on you. And my learned solicitor informed me that he in fact cut and pasted from my learned friend's skeleton argument, so if he had footnotes, that's where they've come from. So that'll be a skeleton argument below, which I can actually give reference to if you would like it, my lady.
It's all right. No, I'm sure I'll be corrected if I'm wrong. I suspect it's definitions of those particular terms.
That's correct, my lady.
Yeah.
my lord, thank you. And I'll come back to those particular clauses, or some of them anyway, when I deal with the grounds of appeal. Before getting there, however, can I move on to my next submission, which is what are the characteristics of a consumer?
Yes.
And this I can deal with quite quickly. I've already made the point that in respect of Mrs. Parker-Grennan, in paragraph 47 of his judgment, which I'll take you to just momentarily, the judge treats Mrs. Parker-Grennan as if she was a non-consumer on the question of incorporation. It's page 83 of the core bundle I'll take you to. It's the last sentence cell, the last two sentences. Mr. Coose's submission that no one reads these documents puts the matter too high. Some people do. The claimant would, of course, be bound by any document she did, in fact, read. With respect to the learned judge, that's not correct. A consumer will not necessarily be bound by a document that they've looked at in the way that a commercial entity might be so bound. Because, for example, the document has to be intelligible and it has to be fair.
Yes, you say this simply begs the question which has to be decided under the regulations of accessibility, intelligibility and fairness.
That's
The mere fact of reading is not conclusive.
No, that's exactly right, my lord.
Yep, understood.
And there in particular, when I come on to ask for the court to give guidance, I think that's very important that that guidance be given, because there are a number of authorities dealing with consumers that simply have ignored the fact that consumer contracts are different.
Yes.
And with respect, well, not with respect, the mistake I think I fell into at first instance was I went to deal with the unfair terms of consumer contract regulations prior to dealing with the terms of the contract, and the learned judge asked me to deal with the terms of the contract first of all. And I think that approaches it in the wrong way. I think you have to ascertain, is it a consumer contract, and what effect does that have upon everything that follows in terms of construction and incorporation. So the average consumer is someone who is reasonably well informed, reasonably observant and circumspect. And you take that from my skeleton argument for this hearing at page 22 of the core bundle. It's in paragraph 3, 1, 2, 3, 4 lines down from paragraph 3. And the authority by which that's given is a footnote 1, which I'm not even going to attempt to pronounce.
Springenheid.
Oh, there we go, my lord. There we go. And the reason that I'm not taking you to the authority is because it's common ground between myself and Mr. Hinks that that's not in dispute.
It's the man on the Paris metro.
Yes, yes, I suppose so. And one also then goes to paragraph 17 of my skeleton argument, which begins on page 33. And what you see, and I think this is important as well, is just above paragraph 17, the end of paragraph 16. The learned judge sets out paragraph 19 of the judgment from Spreadex and observes at the beginning of paragraph 17, this final sentence is particularly important. I say that that's very relevant because he's then fallen into error in the way in which he's assessed the particular contract under consideration. He hasn't treated the last sentence as being particularly important. He's actually put it to one side. But staying with paragraph 17 and moving over the page to page 34, one then has the well-known dicta of Lord Reed and the Swiss Atlantic case. And again, that's not in the authorities, and again, that's because it's not in dispute. In the ordinary way, the customer has no time to read them. And if he did read them, he'd probably not understand them. And if he did understand and reject any of them, he would generally be told he could take it or leave it. And then if he went to another supplier, the result would be the same. And there's a footnote there, which I'll take you to in a second. But I say that's absolutely correct. So what you have for an average consumer is someone who, as we know, reasonably well informed, reasonably observant, reasonably circumspect, and who doesn't have either the time or the power to do very much about standard terms. And that's the reason that one has to approach the question of incorporation and then construction by reference to the regulations, or now the Consumer Rights Act. And I pointed out the footnote, which refers to the Royal Commission's paper, The Unfair Terms of Consumer Contract, a New Approach. Perhaps I can invite, that's tab 17 of your authorities. Perhaps I can invite you to read paragraphs 3.5 to 3.14 of the Royal Commission's paper.
Station joke. We like 314.
I thought you might, my lord.
So this is what's described as an issues paper, which is a paper which the Law Commission produces before they ever get round to producing even a consultation paper. So it's really just throwing out into the public domain, here are some issues which the Law Commission might in the future embark more fully upon. And I don't think they did in this occasion, did they?
I'm not certain they did. Certainly my researchers haven't.
No.
But I do say that everything that is said there is germane to what your lordship and your lordships and your ladyship have to determine for purposes of this appeal. And I say very clearly that the judge was wrong to treat the question of incorporation and construction in the same way that it would apply as between commercial entities. And that
Do you accept in principle that the process of construction and applying 7.2 involves a court, first of all, construing it normally and then coming to a conclusion as to whether there is a doubt? If there's a doubt, you can then construe it again in favour of the consumer. Do you accept you have to go through a normal process of construction? So we might or might not conclude that the terms on the box, as it were, give rise to confusion. If we do, then the benefit of the doubt is in favour of the consumer.
I do accept that. Yes.
Yeah.
Now, my lord, from there we move to my last submission, which is the grounds of appeal as I've set them out in my skeleton argument.
Yep.
The first ground of appeal is the allocation of risk, and of course, and that you find in the core bundle at pages A21 to A23.
Yes, this is the 1900 times point.
It is, and to a very large extent, of course, I've already dealt.
So there's first of all our concern about statistics, but then
Yes.
the underlying issue is, which I think comes out of clause 11 of their terms and conditions, about they effectively provided it's reasonable, they can declare a trade or a bet defective, so they can allocate risk away from themselves, subject to a test of reasonableness in their own, I think it's clause 11.
Yes.
1.4.
As your ladyship says, Soto Voce 11.4, yes.
So let's assume, just to test the point, we're against you on the 1900. Nonetheless, there was a mistake, common ground. It wasn't your fault, common ground. It was their fault, common ground. They can allocate the risk away from themselves if reasonable, or they have a discretion provided it's exercised reasonably. Now, there may be a dispute between as to what's meant by reasonably.
Well, I'm going to come on to that when I deal with the Braganza type clause
Yes.
issue. But by way of headline argument, I don't make the ambitious submission that Mr. Hinks suggests in his skeleton argument that the Braganza clause can never apply in the context of a consumer contract. I do, however, say that where it purports to oust the jurisdiction of the court, it must always be unreasonable for it to do so, because how as a consumer, it's very well that the judge knew that the court's jurisdiction can't be ousted in that way.
It can't oust the jurisdiction of the court if it's subject to a requirement of reasonableness, because the court will then determine whether it's been reasonably exercised.
And that would be fine when dealing with lawyers like ourselves and like the learned judge below. The difficulty is when you say to a consumer, my decision will be final and binding, that's
The
what makes it
signalling
unreasonable.
effect.
Yeah.
The signalling effect may be unreasonable. The mere even if it's not enforceable in court, its mere existence as a communication to a consumer may be so deterrent that it would be unreasonable for that reason alone.
Exactly, and for that reason should be struck down. So that's what I said. That's what I will come on to say about that. So yes, I think you have my point that, of course, when assessing unfairness under Regulation 6.1, one of the circumstances present at the point that the contract is concluded, my lord, is the fact of the coding error, and we've been through that, my lord, and I know you have the point.
Yep.
So from there, and I'll do it in a little more detail. The second ground of appeal was incorporation, and this is pages A23 to A25 of my skeleton argument.
Yes.
And the first point is that of click-wrap agreements, and the learned judge deals with that in paragraph 45 of his judgment, which is A82.
And he says that you can, click wrap can incorporate the terms in and of itself.
He does so by reference to Ebury, of course. And the difficulty with that is that Ebury is not a consumer contract at all. It's dealing with quite complicated money trading facilities. And you've got two commercial entities who can be expected, A, to take advice if they need it, and B, to look after their own interest and know the law.
This is Justice Foster, I think, took a slightly more nuanced view in the paragraph we were looking at earlier.
She did.
She said she wouldn't preclude the possibility that click could incorporate, but she didn't say it necessarily did.
No, that's absolutely correct.
Yeah.
And I'll just quickly take you to two paragraphs of Ebury. It's tab 14 of your report, please.
This was forex trading, wasn't it?
It's certainly trading of some description, I think.
Yeah, it was forex.
Yes, foreign exchange, absolutely. And I rely upon paragraphs 8 and 9 to show you where the judge has fallen into error.
Of course, the judge there is applying the basic rules that are set out in Chitty in relation to bringing the terms to the attention of the other contracting party. Even consumers in the days before this sort of deal was done online would be bound by terms that were in small print on the back of a ticket or an invoice. However unfair that might appear to have been, hence Lord Denning's diatribe.
Yes.
That's why the legislation was enacted, to bring into account protection. So they're bound by the terms on the face of it because they're incorporated in the contract. But then there is a power in the court to redress the balance in favour of the consumer by saying, well, we're not going to treat these terms as binding for the following reasons, because they're unfairly stacked against them.
And that's why I draw it to your attention as demonstrating why it is I say the learned judge below fell into error, because there is this distinction. I mean, as a statement of the contractual position between non-consumers, paragraphs 8 and 9 are completely unobjectionable, and paragraph 6 before it that you're referring to, and 7 before it that you're referring to, and it's really unobjectionable. But that's why it's so important to start from the position that this is a consumer contract to which different considerations apply.
I think we're slightly at cross purposes, Mr. Causer.
Very possibly.
The point I'm making is that the rules, subject to the concerns that the court may legitimately have about the idea that clicking a box will necessarily incorporate all the terms and conditions for every case, is that there isn't a separate rule for consumers from everybody else, because the question is, in each case, has enough been done to bring these terms and conditions to the notice of the other contracting party? And that's got to be a question of fact and degree, in which the fact that somebody is a consumer will play an important part. I accept that.
Yes, yes.
But I wouldn't want you to think that I'm accepting your proposition that there's a separate rule for consumers from everybody else.
I say that necessarily the effect of the consumer protection legislation that's been put in place since I think it's about 1973 is to alter the position such that when one's looking at business-to-business transactions, one approaches it in a different way to how one approaches it when dealing with business-to-consumer transactions. Now, I'm not saying that that has always been the approach that the courts have taken, and it's one of the reasons I do seek guidance on how consumer contracts should be approached, and in particular, how they should be approached when dealing with matters online, but more generally as well. Because I say there is a distinction, and that's why I say you have to start with the relevant consumer protection legislation first, be it the regulations on the Act, and then look to see how one approaches the question of construction and incorporation. So I think we are at cross purposes because I go slightly further than you, I think, my lady. I accept the general proposition that there was no distinction historically. What I say is that the effect of the legislation now is to create such a distinction. And I say such a distinction is right and proper.
I'm wondering how far you are, in fact, apart, assuming you're correct. And now we've got the unfair contract terms regulations we had up to the Unfair Contract Terms Act. Now we've got the regulations that defines a consumer contract where there's an imbalance, and it applies protective rules. But quite where you are on the spectrum from B to B to B to C may vary, even with the unfair contract terms regulations, even with consumers. There may be different degrees of sophistication and so on and so forth. It's still a spectrum, isn't it? Which I think is all my lady is saying. It's very highly fact and context specific. And I think you're saying what one of the facts and contexts which make it more specific is the existence of legislative protective regimes for consumers.
Yes, that's not quite how I put it, but yes, I don't disagree with what you're saying, no.
I mean, I'm not sure that at the moment, if you're going so far as to submit that there is a completely different regime as a result of the legislation. The way in which the court asked the question, is this part and parcel of the terms and conditions of the contract, is altered in some way. I'm not sure I buy into that. I can quite understand the argument that when one is considering how many of those terms are binding on the consumer, there will then be a very highly fact-specific inquiry. And I can also see how when you start at stage one and you ask yourself, are these terms and conditions actually part and parcel of this contract? One of the important factors that you take into account is the degree to which the consumer is given notice and the chance to opt out of it, and so on and so forth. And there may be cases in which you say, well, you can't possibly treat this as part and parcel of the contract because they had no notice of it whatsoever in practice. But are you actually saying that we should say that we no longer, everything that's said in Chitty, paragraph 15007, has no application to consumer contracts at all?
No, I can't go that far. I think what I can, and I certainly don't say that it's a completely different regime, which I think is the I know you use. What I say is that one approaches it from the starting position that one is dealing with a consumer contract. And that does, perhaps we are saying the same thing, that does alter the fact delivery assessment.
Yes.
And Mr. Justice Jay himself seemed to allude to that in so he reached the conclusion he reached in paragraph 45 of his judgment, but when the immediately preceding paragraph 44, which is A82.
Sorry, can I just come back to
Yes, please
that
do.
point? Because I think the answer might be that under the regulations, indicative and a non-exhaustive list of terms which may be regarded as unfair, so unfair albeit
Schedule 2.
incorporated, is this point in Schedule 2I J.
Yes.
I, irrevocably binding the consumer to terms he had no real opportunity of becoming acquainted with before conclusion. So it assumes incorporation, but places the onus of the analysis more on fairness than incorporation. That might be quite an important point as to where the real thrust of the legislation applies. Is the protection at incorporation or at fairness? I mean, maybe it operates at both, but with different degrees of intensity.
Yes, I think it does. Well, I think it does apply and operate at both.
I mean, if something's 10 clicks down and you've got and the website is time limited to 3 minutes and you never get there, a court might say that just was never incorporated, even though you...
That would be a very easy case, absolutely. But I don't say it's any different when, even though I say that the terms and conditions in full says at the date that Mrs. Parker-Grennan played this game are clearly more legible and more manageable at 11 pages.
Understood.
Instead of
Absolutely, yeah, we've seen that.
But still, you have to read those 11 pages in total and all of the other documents. And so it's not 10 clicks down.
No, we understand that.
But it might as well be.
Well, this is where I think everybody accepts there's no easy, perfect answer to this. The trade has got to be protected.
Yes.
And impose its terms. The consumer also has to have a proper opportunity to grapple with them and understand them.
My lord, yes, and that is the reason why I seek guidance, as you know.
No, understood. Thank you very much.
But I will take you to paragraph 44 of the learned judge's judgment, which is at A82. And so, having directed himself by reference to the right consideration, albeit saying, I wouldn't like to say if people ever actually read them or not, what he should have found in my submission is that a click-wrap tick box without more is insufficient to bind a consumer to the minutiae of the terms and conditions that sit behind that tick box. And that leads to paragraph 7 of my skeleton argument, at page A25. Should the Court of Appeal provide guidance as to the use of tick boxes in the context of consumer contracts? And I say you should. I don't say that tick boxes, quite a difficult phrase to say actually, can never lead to incorporation in the context of a consumer contract. But I've set out to you before, and I don't think I need to repeat it, what I say should actually occur. That you've got to actually click on it, you've got to scroll down it, and only then can the I agree light up. And as I say, and I'll make the point again, I'm sorry if I'm labouring it, that actually just harmonises the position with what happens in the real world, where you've got to get past the terms and conditions to get to the signature box. And I've made the point, but I'll make it again. Even if what they do on the click wrap tick box is sufficient for the purposes of a corporation, that doesn't mean they get home on fairness. You have my point, my lord. We then come on to paragraph 8 of my skeleton argument, which is at page A25. And in paragraph 59 of his judgment, the judge decides there's nothing onerous or unusual about the defendant's contractual provisions. The relevant contractual term, the match 2 winning numbers to your numbers to win, was the only contractual statement specifically drawn to Mrs. Parker-Grennan's attention prior to the contract being concluded. And of course taken from verbatim from the top tier contractual document, the game procedures. And in context, it's important to put it in context, a win was something the game had been programmed to do and something that the relevant contractual term said could happen. And Camelot seeks to circumvent that outcome by relying on its own subjective intention that something else should have happened. Well, you have my point about objectivity, not subjectivity.
Yes.
It's simply unfair, we say, to allow Camelot to rely upon what assessed objectively in the circumstances are in context onerous and unusual clauses. And here I'm talking about clause 6.1 and 12.1 in particular.
Yeah. That's all I'm going to say about that ground. We then come on to the ground of appeal located at pages A26 to A27. Which relate, and we're all very much on the closing straight now. Really pleased to hear. No, you've been very helpful.
Which relate to Mr. Smith's witness statement, because Mr. Smith's witness statement is in the supplemental bundle. I'll just give you the references rather than take you to it again.
We've looked at it already, haven't we?
But you have, but I want to give you the references in full because the witness statement is at pages A22, A22 to A35, but it's then supplemented by a 150 plus page exhibit at A36 to A189. And the important point here, and it's why I don't need to take you to it again, is no consumer has the benefit of any of this information. But in paragraph 64 of the judge's judgment at A86 in the core bundle, perhaps I'd invite you to read paragraph 64 to yourselves. my very simple point there, my lord, is that if the learned judge can only understand clause 3.1, 6.2d and 6.3e of the IWG rules, once he has the benefit of Mr. Smith's witness statement, which no consumer would ever see, no matter what they clicked on, no matter what they read, then no consumer is ever going to be able to understand those clauses at all. And so they cannot be intelligible, they must be unfair, and clause 8.1, regulation 8.1 of the Unfair Terms of Consumer Contract Regulations means that they can't apply as against Mrs. Parker-Grennan. And that's the conclusion that the learned judge should have, but did not reach.
You say that the, what's it called, the game procedures is the primary contractual document.
I do. That comes from clause.
Yeah, I understand that. Which says this game is a game of chance.
It does.
The outcome of the play in the game is predetermined by Camelot's computer system at the point of purchase. You don't have to exercise any skill or judgment. You just press the button and the computer decides what the outcome will be.
I accept all of that. That's a signposting issue, my lord, because the fact of the matter is, in terms of signposting, what's been signposted to Mrs. Parker-Grennan at the point of the contract is the relevant contractual term. None of the rest of that, which could have been signposted, is set out on the game screen.
None of the rest of what?
Well, so the points that you've just read out, my lord, about the games of chance and what have you,
Well, yes.
One has to go behind the game screen to get to that.
Yeah, but you don't have to have the evidence of Mr. Smith.
I'm so sorry, Lord?
You were saying without the evidence of Mr. Smith, you can't understand how it works. Well, I'm asking you to consider that if you look at the game procedures, that tells you how it works.
My lord, if a consumer is going to go and read the game procedures.
Yes, I understand that.
Yes.
But you were saying the judge was without Mr. Smith's explanation.
Well, the
all
judge
of this
said,
was impossible to understand. I mean, with great respect to the judge, I'm not sure it is that difficult.
well, my lord, I can only make the submission that I make.
Yes, all right. But anyway, you say you have to get to this point to understand it.
Yeah, whereas what's clearly signposted at the point of the contract is the clause I rely upon. The match two of your numbers to any winning numbers.
We do have to inject some air of reality into this. Somebody's playing a lottery, they know it's a game of chance. They know that there may be a chance that they've got a winning ticket. They may have a chance that they haven't got a winning ticket, and they know the odds are stacked against them of winning one of the biggest prizes. They don't actually need that spelt out in the terms and conditions at all, because they know that that's what they're doing when they're playing a lottery.
They're not playing a lottery, of course, and without wishing too much to give evidence from the bar, different slot machines, for want of a better word, operate to different rules. And it's, I absolutely accept that if one gets into the game procedures, one sees that this is a game of chance and it's not a game in which one is exercising skills.
Well, this is a scratch card. It's a bit like winning the golden ticket to Willy Wonka's chocolate factory, isn't it?
Well, it's a beautiful analogy, my lady.
I mean, it is. It may not be immediately exactly the same as a lottery, but I mean, it's self-evidently a game of chance.
Exactly.
I mean, you can't affect which numbers appear.
So what I can, and again, there's no expert evidence to this, so to this effect. So at the point you want to stop me, please just stop me. But there are different ways that this can be arranged. One is that a different outcome. So here it's predetermined at the point that you press play. In other games that will be predetermined before you press play, it's just predetermined because of the payouts. And in some other games, there can be an element of skill involved as well. And all that the player knows, unless they go to the game procedures, is what they are told they have to do on the game screen prior to the contract being formed.
But I may not have understood this game at all. When you start, you've got a screen which has got at the top something covering up the numbers,
Yep.
and at the bottom a lot more numbers and something covering them up, and you just sort of press on the money bags or the pound signs or whatever it is, and the numbers are uncovered.
Yes, I mean,
Well, there's no skill in that, is there, apart from pressing a button?
well, if it were so if it was simply that the numbers are there, and so you've got the numbers 1 to 100, and you've got to press one of them, and if you press 1, you might get £1. If you press 100, you might get £100. But that all of those are there somewhere, then there is an element. It's not the player would regard it as skill. I think that they pick the right number to get the highest prize.
Well, whatever they might think, it's not. There's nothing skillful about it. It's predetermined. I mean, even if it's one of those games that says that would where you've got a slightly more sophisticated computer program where it depends in which order you pick them, and so you've got to get them in a particular order. So you could have all the right numbers, but in the wrong order, and that wouldn't match. I mean, there is an element of more of chance in that, and some people might say it was a skill, but it's not like poker where you can actually apply some kind of method or statistical method to winning.
Well, I don't. So I don't think the poker. Poker's not a great analogy. I don't think.
No, it's not.
Because of course you get the 2 cards you get. If we're talking about Texas Hold'em, which I presume we are, you get the 2 cards that you get, and then it's about playing, if you're good enough, the other players.
Yeah.
So I'm not sure that is the
But
right.
that is a game of skill.
Well, that part of it is, which is why I'm no good at it.
Once the cards are turned over.
Yeah.
Once the cards are,
Yeah.
yeah. Okay.
Well, before they turned over, yes.
Frankly, the two of you have lost me now
Yeah, sorry.
with these dubious practices. I mean, the point is, it's done by pressing a button.
Yep.
Then there's a result. A consumer might think they're exercising some sort of skill, but it's a pretty mechanical process. And I think my Lord's point is that even if the judge below was confused,
You're not.
maybe, well, I'm always confused, but it may be through his lack of experience of playing games. He's a very cerebral chap. Anyhow, but what does it actually lead to? Let's assume you're correct. There's an element of skill in it. Then what?
Well, no, I don't say there's an element of skill in it. What I say is that if one's looking, as one has to here, as to what's fair,
Yes.
Mrs. Parker-Grennan is presented with one contractual provision prior to the contract being entered into. If Camelot had wanted to signpost other contractual provisions, they could have done so.
Yeah.
And they've chosen not to. And so, leaving aside the questions of incorporation that we discussed earlier,
Yes.
in terms of whether or not Camelot should be held to what it said could happen at the point of incorporation, which of course is what 6.1 deals with, regulation 6.1 deals with.
Yes.
I say it should, and that going behind that to then get to the grading procedures shouldn't be permitted.
But the bottom line is that you say your client was told in terms that if certain things happened, she would win. And those certain things did happen. The fact that it happened as a result of a computer error is neither here nor there. And it's unfair to rely on a term which takes that away.
In a nutshell,
Yeah.
yes.
That's it.
Yep.
And the fact that it's a game of chance is irrelevant, because
On that analysis, yes, my lord.
she's saying, all right, it was a game of pure chance, but the contract said that I might have 2 chances.
Yep. That is entirely wrong. I mean, I think.
Or 3 or 4.
Well, absolutely. On the wording of that, it simply says match.
Numbers.
Yeah, match the numbers. Yeah.
All right.
My lord, I then move on to the next part of this ground, which is at pages A28 to A29 and paragraphs 10 to 11 of my skeleton argument, which is A29 to A30. effectively, I've already prefaced what I'm going to say by reference to Braganza style clauses. And I made the point, and I'll come back to Goodrum in a second, but I made the point that I don't say that a Braganza style clause can never apply in the context of a consumer contract. What I say is that will always be onerous and therefore unfair for a consumer to be told that a decision is final and binding, and one goes back to the IWG rules at page in the core bundle A151, 6.1. And I'll sentence Camelot's decision about whether a play is valid will be final and binding. And then in 12.1 at 153, Camelot's decision about whether or not a play is a winning play or in relation to any other matter or dispute arising from the payment or non-payment of prizes will be final and binding, provided that it is a reasonable decision. And I say...
Your position would be very, very strong indeed if it didn't have the proviso, because it's in the list of objectionable terms that's in the regulations. And any term which makes one party to the contract the sole arbiter of disputes or anything else is on the face of it unfair.
And that's why I say that 6.1 is particularly offensive, because it doesn't have the proviso. But the 12.1, even with the proviso of it being reasonable, it still purports to oust the jurisdiction of the court, and that will always be unfair in the context of a consumer contract.
I think if someone stood up in a court such as this and said you can't hear this appeal because the contract ousts it, would simply invite the response, well, that depends upon whether it's fair and valid. If it is, then in a sense it doesn't matter why you lose.
And I couldn't agree more, and I make that point. I agree with that point because I've made the point that it's all well and good that the judge knew that the court's jurisdiction can't be ousted in that way, and that we know it.
Yeah, but it's the signalling point you say that it actually deters people from bringing in challenge.
Because one has to look at who it is we are aiming this at, and it's being aimed at consumers. And particularly if you want to look upon it this way, at consumers who play fruit machines online. The judge's reasoning is also difficult because it's based in large part, it's at paragraphs 73 and 74 of his judgment, and it's based in large part on the decision in Goodrum and Camelot. And instead of about citing cases in which I'm one, well, it's good to be able to cite one for this defense. At 10 of the authority. Now, Goodrum is quite a difficult case. It's undoubtedly the case that Mr. Goodrum didn't deserve to win £4 million. It's also undoubtedly the case that it wasn't particularly well handled by Mr. Goodrum's counsel, or it doesn't appear to have been well handled by his counsel, because first and foremostly, when one looks at the circumstances as set out in paragraph 6 of the judgment, and in particular Mr. Goodrum's explanation for how it is he came to have this winning scratch card. A more fanciful explanation it would be difficult to conceive of.
You were talking about card games earlier. Mr. Goodram's counsel didn't deal his counsel a very good hand, did he?
If you're on paragraph 15,
Yeah.
the judgment on all, absolutely not. I mean, it does smack of sharp practice, I'm afraid.
I think smacks of is putting it a bit low.
Well, Mr. Hendren has enough difficulties without me compounding them. What's also not made clear, so this purports to be a consumer case, and at various places within her judgment, the learned senior master, forgive me, refers to Mr. Goodram and his compatriot as consumers. But although it was pleaded as a consumer case, what seems to have happened is that the point has been raised, presumably by Mr. Hinks, and quite properly, there's no criticism of him, that actually this is pleaded by reference to the unfair terms of consumer contract regulations, but the Consumer Rights Act is now in force and the regulations have all been repealed. What one might have expected counsel to do at that point would be apply to amend. But if he did, there's no record of that within the judgment. Mr. Hinks may be able to help you with that, I don't know. And if he didn't, it's not clear to me why he didn't. So although this should have been dealt with by reference to the consumer legislation, it simply wasn't. And again, this was decided by reference to a number of the commercial cases that Mr. Hinks will take you to in argument when he gets to that point in the day. I do say it's a difficult case. I say that learned senior master reaches the wrong decision, albeit that as a matter of justice and a matter of what would have happened eventually, had the matter of gone off to a trial, is that Mr. Goodram would have inevitably lost. I mean, it would have been a dream to cross-examine him. Nonetheless, at that stage, what should have happened is a summary judgment should have been refused, and the matter should have proceeded to trial because there were tribal issues to be dealt with. And of course, the test is it manifestly incredible what he's suggesting? It's certainly incredible, but does it clear the high hurdle of manifestly incredible? Well, I say it doesn't, albeit it's a close-run thing. And that for that reason, for understandable reasons, but without the benefit of the consumer legislation that she should have had the arguments addressed by, the learned senior master has fallen into error, and that's a decision that can't be defended.
The judge below said he's not going to follow the senior master, he's going to form his own view.
He did.
Though he was attracted to the broad abstract reasoning of the senior master. So what's your analysis of the Braganza position? What's your bottom line?
Well, my bottom line is, as I set it out, which is that the clause itself is unobjectionable enough if it doesn't say that it's ousting the jurisdiction of the court. And clearly it then also has to be reasonably exercised. And so the only problem with clause 12.1, and one of the problems with clause 6.1, is the purporting to oust the jurisdiction of the court. That is what I say is unreasonable. That's what strikes it down as a clause.
There hasn't been an application at the beginning of this appeal that we should immediately dismiss your appeal upon the basis that we lack jurisdiction, which would have been the conclusion if it was being construed as an ouster clause.
Well, the fact that it's not pursued as one doesn't mean that it doesn't purport to be one. When one is...
it comes back to your signalling effect.
Well, that's it, and one has to look at it from the point of view of the person that's due to receive it, the consumer, literally the consumer.
Yeah, understood.
That moves then to the third ground of appeal, which is enforceability. Now, the first point is that the judge relies upon what I say is misplaced distinction in respect of Beckford. And this paragraphs 12 to 13 of my skeleton argument, A 30 to 31 of the core bundle. Yeah. judge describes Betfred as a strong case because there could be no question but that Mr. Green had won in Betfred. But that's not correct at all. It was not accepted in Betfred at all. Betfred simply did not accept that Mr. Green had won the money which was ultimately awarded to him. The only possible distinction, and I'll come on to why it's wrong, is that Betfred made a concession which Camelot have not, which is that Mr. Green could theoretically win the amount of money he had won, but the odds of him doing so were vanishingly slim. But Mrs. Parker-Grennan's case is that she also could win, because that's what the game had been programmed to do. And so the only way Camelot can get round that is to say, well, that's not our intention. And that, of course, is not the relevant criteria. It's what the game had been programmed to do. It's what the relevant contractual terms said could happen. And the judge simply, I'm afraid, doesn't deal with that at any point in his judgment.
Yes.
My next round of appeal, still on A31, let's go with an argument, in paragraph 14, is the point I've actually already made to you, and I'm not going to labour the points that I think you already have, which is there is an interaction between 6.1 and 7.2 of the regulations that the judge doesn't deal with.
Yeah.
And so to discuss that, we move on from there, A32, the judge was wrong in fact or law. Creates significant imbalance in the parties' right. The key point there, and again it's a point I think I've already made, is reliance is placed upon the need to ensure the integrity of the national lottery and protecting the defendant's odds and pricing structure.
Yeah.
There was no evidence before the court as to what integrity meant in that context. But in any event,
Well, they can protect themselves in other ways, you say,
they can sue the
either by
code.
suing or insurance or both.
Or both, yeah, that's exactly it, my lord. Yeah. So this comes back to the click wrap. This is A32 to A33 point and the interaction with Regulation 5. And the judge alights upon the word irrevocably. And in fact, he simply paid insufficient regard to the fact that this is a consumer contract.
So this is the some people do, and you say that assuming that's correct, that's not a generic analysis of consumers in the situation that you're confronting.
My lord, you have the point. I'm trying to get through this as quickly as possible, I promise.
You shouldn't feel rushed. There's 4 minutes to 1.
No,
There's plenty of time. Yeah.
No, I heard what my lady said, and I don't. I'm just conscious of the fact that if you have my point, and even if you were massively with me, I can only win once, and so there's no point in my pushing the
Fair
point.
enough. I just didn't want you to feel rushed.
No,
at
absolutely,
all.
don't feel rushed.
No, well, I'm very grateful for that indication. Yeah.
We're conscious of the fact that the clock over there has stopped, so
I have my solicitor's watch because I made the point to him that I don't wear one myself.
Strictly speaking, it hasn't stopped. It's moved about 20 minutes in the last 2.5 hours.
The second clock, the second hand is working well. The first hand, time is moving very slowly in his court.
Parts of it are excellent. As Scott knows. I mean, just the final point on irrevocability is that, in actual fact, Mrs. Parker-Grennan is irrevocably bound to the claimant's terms and conditions at the point she presses play, because of the fact that it's common ground that that's the point at which the contract's concluded. And so focusing upon irrevocability to the exclusion of everything else, I think the judge falls into error there as well. My lord, I've dealt with Braganza style clauses already. I make the point in paragraph 18, the appellant repeats paragraphs 10 and 11 of the Scope argument. I have nothing more to enlarge upon that, and so I don't intend to do so. And that brings us to the construction issue. And I set that out at A35. And once again, I simply repeat what I've already said earlier about that, and I beyond inviting you to reread what I do say in paragraph 14, I have nothing separate to address you on. My lords, I'm going to, with your permission, turn my back on you and take instructions.
Of course.
We should give him a chance after lunch to at least have a
point, I think that you already have, although I know the solicitor's right to put it more eloquently than I think I have, and also just to remind me of one further point, is that the court obviously cannot change what the definition of an average consumer is, but you can require traders to adapt to the digital age, hence the guidance I invite you to give, and comply with the public policy aspect of consumer protection. And in that respect, in tab 15 of your authorities, there's an authority that went in late because it only came to my attention late, called Claimant Incorporated. It's a decision of Mr. Justice Bright in July of this year.
Yep.
Bear with me for a moment. In paragraph 118 of the judgment, under the heading is, no, I'm sorry, that's a false reference, bear with me. Yeah, I think I did. Thank you very much. Yeah, if having considered Article 3, the Justice Bright concludes it follows in section 62.
Sorry, which paragraph?
Sorry, 117.
170, yes.
So it follows in section 62. This is the Consumer Rights Act.
yeah.
Yep, absolutely, my lady. Must also be treated as an expression of UK public policy in the light of Mostaza Claro, because it enacts the Unfair Terms of Consumer Contracts Directives. Once again, this is a conclusion I would have come to. And also of relevance under the heading enforcement would be contrary to public policy of section 62, paragraphs 132 to 137 of the judgment. I simply invite you to read those paragraphs to yourself.
Yep.
Would you also like us to read the highlighted bit from 104 to 110, which sets the scene for the discussion of the Consumer Rights Act?
Yes.
We will do so.
We will do that.
Yes, I'm grateful to you, my lady. Thank you. There's a reason I've coloured it in red, and of course I've then overlooked that. My lord, unless there's any further matter I can assist you with, I'm conscious of the hour, and so
No, not at all. We won't. We will start at 2, but we will give you till whatever time after 2, in case you have second thoughts and you need to cogitate over lunch and come back with something. So we won't immediately start with you, Mr. Hinks, but we will start very shortly after 2, subject to anything you wish to say.
I'm very grateful.
Thank you very much indeed.
All rise.